He asked for bond. Then the judge read his criminal history. The courtroom went silent. What came next could mean life in prison. The defendant asked the court for bond. As the judge reviewed his criminal history, the courtroom became silent. The man was identified as John Gillery III. He was charged in 2 separate cases. Both charges involved unlawful possession of a firearm by a convicted felon. Each charge was a third-degree felony, committed on different dates.
One of them was from November 26, 2023. The other was from December 14, 2024.
All right. And each of these also show that you have several prior convictions. 2007, February 5th, 1, 2, 3 convictions of illegal possession of controlled substance and unlawful possession of a firearm by a felon in 2007 out of the 252nd District Court of Jefferson County. Thereafter, those were all final. It is alleged that you committed the third-degree felony of unlawful possession of a firearm by a felon and were convicted of that on February 9th, 2009 in the 252nd District Court of Jefferson County, Texas. After that conviction was final, it is alleged in paragraph 1, 2, 3, 6 that you committed the felony of escape from custody, a second-degree felony, and were convicted of that offense in 2010 out of the 349th District Court in Houston County, Texas. After that conviction was final, it is alleged you committed the offense of unlawful possession of a firearm by a felon, a third-degree felony, and were convicted of that on December 14th, 2022 in the 252nd District Court of Jefferson County, Texas. So if all of this is found true, this is a third-degree felony enhanced as a habitual felon. You were looking at then no less than 25 years to 99 years confinement in prison or life imprisonment. You understand what you're facing in 24 CR 79.
Yes, I do, Your Honor.
In 25 CR 434, you are charged with a third-degree felony of unlawful possession of a firearm on or about December 14th, 2024.
The judge explained that the defendant had prior convictions. Because of his criminal record, he was charged as a habitual offender. This changed the punishment range significantly. The court stated he could face 25 to 99 years in prison, or even life imprisonment.
Do you understand what you're looking at in this case?
Yes, Your Honor.
Okay. What are we going to do?
Judge, initially he wants to be assigned a trial counsel off the trial, but he also would like the court to set the bond for him in each case.
Okay. So there's no deal in this, right?
No, Your
Honor. Okay. Then these will be set for trial one at a time. Do you understand these convictions can run consecutively as well? All right. What state?
Your Honor.
Say anything?
As far as the bond issue, Your Honor, we would ask that the court again keep his that he not having bond right now. As far as the look at his criminal history, the danger and why he was on bond for this other case, he ended up committing a new offense. So they believes that he's a danger to the community for that. And ask that he not be granted a bond, or that if he is, that it's asset to be like $500,000.
Anything the defense wants to say?
Judge, yes, sir. Mr. Gillery is currently employed at Better World Properties. My understanding, he does have a job waiting for him. They do need him back. He's the property manager, maintenance manager of several properties here in the area. His wife is here in support of him. He does have 2 other children at home. He does have a stable house, some stable employment. He is eager to have his court date and say that he is not guilty of what has been charged with. if there may be some legal issues in the mix that I'm assuming is a new topic, so granted to be addressed. He does have family in the area, and he is willing to accept the conditions of bond that the court would impose.
All right, anything else you want to say?
Yes, Your Honor. Well, for one, the state is attempting to proceed against me via a void indictment. There was no probable cause for the stop.
The judge said the grand jury had already reviewed the evidence. They officially indicted the defendant based on that evidence. The defendant asked the court to grant him a bond. The judge acknowledged the request, but restated the serious nature of the charges.
I'm sorry, with illegal possession of a firearm in each of these two cases, the court notes that your indictment go on to allege that you have 1, 2, 3 prior convictions of unlawful possessions of firearms by a felon. You have now picked up 2 more. I have read the probable cause affidavits, and on 24 CR 79, it is alleged here, according to the probable cause affidavit, that the firearm alleged that you possessed illegally was in the waistband of your sweatpants. Okay. And then 25 CR 434, in that case, you were stopped and the Beaumont police patted you down and you had drugs in your left pants pocket. And then you were the driver of this vehicle and you were arrested. They searched your vehicle, and under your seat was Smith & Wesson .380. All right. Your bonds are $250,000 in each case. In each case, if you post your bonds, because you're a habitual felon long ago, 3 convictions ago, if you happen to be able to post the bond of $500,000 on this, you must be in home confinement. You must have a GPS on you at all times. You cannot leave the house except for emergency medical care or food or work, and that's to and from directly the most direct route possible from your home. And you obviously would be on other conditions such as do not possess a firearm or commit any other criminal act.
The defendant requested to speak for himself in court. The judge explained that his attorney would still represent him. This type of arrangement is called hybrid representation, where a defendant can speak but still has a lawyer assigned.
You can't do it that way right now. He's representing you.
It's a motion to make counsel judge call.
What steps would I take, Your Honor?
Talk to him, and you can come back and talk to me. All right. You're going to do it legally. All right. Anything else?
That's it.
That is all. We are in recess. Thank you. Any other matters we have to?
2 felony gun charges, an habitual offender enhancement, and a possible sentence of 25 years to life. This is how fast freedom can disappear.